Imagine doing everything you thought was right, drafting your will, signing it, putting it away, only to find out too late that it doesn't work. That happens more often than you think. And when it does, it's not you who pays the price, it's your family. Coming up in this video, I'm going to show you 3 things you need to know before you decide to do your own will. First, what can actually go wrong when people try to do this themselves, and the specific mistakes that cause problems later. Second, how to tell if what you've done is actually valid, or if you've made a mistake without realizing it. And third, how to decide whether doing it yourself makes sense for you, or if hiring a lawyer is the smarter move. Writing a will yourself is a little like taking a test, except you don't get the results right away. In fact, you don't find out if you passed until after you're gone. And if something is wrong, it's your family that ends up dealing with the consequences. That's why one of the biggest mistakes people make when they try to do their own will is something that seems simple, but can completely undo everything that they were trying to accomplish. Let's start with the first mistake: not following legal formalities. In New Jersey, there are a few basic requirements to make a valid will. You have to be of age, over 18. You have to have intent. You're signing the document knowing it's your will. You have to have capacity. You understand what you're doing, what you own, and who your family is. And your will has to be properly witnessed. These aren't suggestions, they're requirements. And this is where people get into trouble. They don't have enough witnesses. They don't sign it correctly. Or they don't sign it in front of witnesses the way the law requires. If that happens, the court can throw the will out completely. And when that happens, it's treated like you never had a will at all. The state steps in and decides who gets what. But let's say you do everything right legally. That still doesn't mean your will works the way you think it will. The next mistake is using vague or confusing language. This happens all the time with do-it-yourself wills. People write things like, "I leave my car to my nephew." But which car? Which nephew? Or, "I leave my personal items to my kids." But what does that even include? And a lot of times people forget to name backup beneficiaries in case someone passes away before they do. When that happens, the court has to step in and interpret what you meant. This can lead to delays, added costs, and sometimes family disputes. It turns a difficult time into something even worse. Mistake number 3 is not naming the right executor, or not naming one at all. If you don't name an executor, the court will choose one for you. And if you do name someone, but they're not the right person, that can create problems too. You want someone who is reliable, organized, able to communicate, and able to handle paperwork and money. You also want someone who won't create tension within the family. And you should always name a backup. I've heard of situations where the executor was someone the family didn't trust. That tension starts immediately and can make the entire process more difficult. Mistake number 4 is forgetting about non-will assets. A lot of people think their will controls everything. It doesn't. Things like life insurance, retirement accounts, and jointly owned property often pass outside of your will. And if the beneficiary designations on those accounts don't match what your will says, or those beneficiary designations are out of date, then the beneficiary designation controls, not your will. So you could leave everything to your children in your will, but if your life insurance still names your ex-spouse, that's who gets that money. And finally, mistake number 5, thinking a will is enough. A will is important, but it's only one part of a complete plan. You may also need a power of attorney, a healthcare directive, a living will, and, depending on your situation, maybe a trust. This is not just about a document, it's about a plan. So when does doing it yourself actually make sense? Well, if you have a very simple situation, few assets, no real risk of family conflict, then maybe doing it yourself could be okay. But the risk goes up quickly when things get more complex. If you have multiple beneficiaries, a blended family, significant assets, or specific wishes about who gets what, the chances of something going wrong increase. Most people think their situation is simple, but many times it's not. So, should you complete a will without a lawyer? It depends. It's really a risk decision, but now you understand what's actually at stake and what can go wrong. But here's the part that most people don't realize. Even if you do everything right, even if your will is completely valid, that still doesn't mean things are going to go smoothly for your family. Because a lot of the biggest problems don't come from invalid wills. They come from confusion, miscommunication, and family disagreements after someone passes away. And that can happen even when the will itself is perfectly written. So in the next video, I'm going to show you how to stop family fights over inheritance before they start. We'll talk about how to make your wishes clear, how to structure things so there's less room for conflict, and what you can do now to make things easier for your family later. If you want to make sure your plan actually works the way you intend, not just legally, but in real life, go ahead and watch that video next.